And welcome everyone. We are now live on social media and also live on Facebook Live and here in the Zoom webinar. Welcome to our third panel of the California Portuguese-American Coalition Summit, and welcome to those following us here in the Zoom webinar and of course on Facebook Live as well. It is on my page, and a little bit it'll be in all the other different pages as well. It takes a few minutes sometimes for it to work. We are happy to continue with the California Portuguese-American Coalition Summit for 2021. We're very excited about this panel as well because it is something very pertinent to California and of course to the Portuguese-American community and all communities throughout the state. We have the pleasure of having with us two attorneys. We have to be careful with everything that we say because they'll scrutinize every single word. But they know me well already. They're fun and very super intelligent people, and so we're very honored to have Maggie Melo, who is Portuguese American, living now in the Central Valley, and John Sarsfield, who wished he was a Portuguese American, but he's a cousin. He's Irish, and the Irish and the.
But I'm not her cousin.
No. See, I tell you, the attorneys have all the right words. We are cousins because the Irish and the Azorians have a little bit in common. We kind of, have a different relationship with the mainlanders or with the other islands. in Irish's case, in Ireland's case, with the other island. And so, and we have in common, of course, this great diaspora. The Portuguese diaspora is just as large as the Irish diaspora. So, so welcome to both of you. And I'll start with Maggie. Ladies first, of course. If you would just give us about a 3 to 5 minute introduction, a little bit about your connection to the Portuguese community.
My parents are both from San Miguel. They got married in the 60s, and they left the Azores. They went to Montreal, where they were sponsored there. And I came along about a year and a half after their marriage. So I was born in Montreal, Canada, and I grew up. My grandmother was then sponsored on my mom's side to go to Canada. And I basically was raised by my grandmother in the home. So I was speaking Portuguese, strictly Portuguese in the home, and then French outside the home because that's the language that is primarily in Montreal. When I was about 10 years old, my parents decided that they had enough of snow because it gets awfully cold there. And coming from the Azores, which is gorgeous and warm, going to Montreal, I always questioned why they did that because it was freezing cold. So they decided to come out to the Bay Area, in the San Francisco Bay Area, where my father was one of originally 13 children. And so we have a lot of family on the East Coast and on the West Coast, but primarily situated in the Bay Area, in the San Francisco area. And so we came there in 1977 or so, where I started school, learned to speak English, went to high school in Newark, California, eventually went to college at Berkeley, and then law school in San Francisco. And in 1993, I finished law school and became an attorney and started practicing in San Francisco. I practiced primarily civil law called misappropriation of trade secret litigation, which means people who stole other people's formulas. And I did that for a while until I decided I wanted to do something a little different. So I came to Tulare County to become a prosecutor. That was in 1990, end of 94, beginning of 95. And I was a prosecutor with Tulare County for almost 11 and a half years. I decided to move down to Kern County to work in their DA's office, and I worked there for a little while. And I was able to, Governor Schwarzenegger at the time was in power, and he appointed me to be on a job called the Office of the Inspector General for the state of California, where we provided oversight for the Department of Corrections. So we looked at civil rights violations, we looked at conduct by peace officers, things of that sort. I did that, and as part of being with that office, I was also a peace officer. So I was a peace officer carrying a gun and all that for 7 years. Eventually, I decided to leave that agency and start my own practice, which I started with my now husband. At the time, he wasn't, but John over there, who's the Irishman. We met at the office of the Inspector General, and then we started our own firm with civil rights violations in mind, which is when we got into the California Voting Rights Act. We were able to start doing cases to basically even out the playing field for elected boards, and trying to get seats at the table for minorities who didn't normally have those seats at the table. So that's about me.
Well, that's a fascinating journey. That is a fascinating journey, and thank you, and a proud journey for the Portuguese-American community. John, your trajectory to today.
Different starting point, but not that different. I was born in Alaska when my dad was working for the Navy, and I was born way out on the Aleutian chain, almost to Russia, on an island called Adak. Moved to San Francisco, eventually ended up in San Jose, where I went to school, went to high school and college at Santa Clara University. Although back in those days, we called it University of Santa Clara. They've changed the name since. Went on to law school there, and went into the Army as a judge advocate. Did that for a couple of years at Fort Ord in Monterey Bay, and got out, went to work for the DA's office in Monterey County for about 10 or 11 years. Then I was the district attorney in San Benito County, which is where I was living, for one term. And then I got appointed to the Inspector General's office by Governor Schwarzenegger back in 2007, I think it was, where I like to tell people we met in prison, which is literally true, but not what people think. And we did that for about 7 years. I retired from state service. And when I was working in Monterey County, I had got the opportunity to see some great voting rights attorneys filing lawsuits and fighting over some organizational questions in Monterey County government. And I kind of caught the bug way back then. This probably was like in the mid 90s. And I always thought if I was in a position where I wasn't working for the government anymore, that it might be an interest. And when we started our practice in Visalia, Visalia was really a perfect opportunity to test out our voting rights practice, because they had done everything from our point of view perfect to be successfully sued and to force the changes. And so that was our first one that we did. And here we are.
Wow. Perfectly suited for for a change. And so let's talk a little bit, the talk that you're going to be giving us and informing us about redistricting, which is something that's coming up now with the new census. We have new numbers. Actually, California lost one, as far as congressional districts are concerned. We lost one congressional seat, or we'll going to lose one. We don't know where it's going to be. There is talk that it might be in the Central Valley. But of course it affects everything, it affects. And so tell us a little bit about the ins and outs of the California Voting Rights Act, and how that both of you alluded to the importance of having the districts and different voices be heard. It kind of gives the voice to those who are sometimes underrepresented, and sometimes underrepresented, but not underrepresented in the population that they represent, but just the way things are. So, well, you're the specialist, and I'm all ears.
What I like to do is I like to start with the generalities about organization of government. And so we start with elected boards. We have elected boards, we have appointed boards, and we have single individuals. Those are really the three types of organizations we have in California. So for elected boards, those are things like city councils, board of supervisors, school districts. For appointed boards, you have your air pollution control districts, you have your state boards such as parole commission, you have your cemetery districts, things of that nature. Generally, those are appointed by a board that has been elected. So the elected board will appoint members to sit on those committees. And then you have single individuals, such as the sheriff, the district attorney, the county tax collector, those folks where there's only one member who's going to sit in that position, and only one person gets elected to that. The cities, which are generally referred to as municipalities, are organized either as a general law city or a charter city. And it's important to know who you're looking at, whether it's a general law city or it's a charter city, because the two are governed by very different principles. A general law city follows the organizational structure found in the government code. Typically in a general law city, there's 5 council members with a strong city manager and a weak mayor. And what I mean by strong and weak is their ability to make decisions and take control of the decision-making ability. Charter cities are those that have been given a charter by the legislature to organize as they see fit. Larger cities tend to be charter cities. They typically have a strong mayor and no city manager. So when you're looking to see who is in control of the organization, it's important to know what controls it, if it's the government code or if they have a charter, because there's several arguments that will come up depending on which one they are. Jurisdictions that elected board members were typically elected at large. Now, mostly they've gone to by district. What it means to be elected at large simply means that you have a 5-member board, and you're going to be voting for those members as an entire city. So if you are a voting member of that city, you're going to be voting for everybody who's on that board. So if there, like for instance, Visalia had 5 members elected at large. Hold on, I'm getting an echo.
Turn your volume down. That's what's causing it. Just have to turn it down. It can't be helped because it's picking up both.
So Visalia used to be held at large elections. And so what would happen is 2 members would be voted in and then 3 members would be voted in. So when you were voting for Visalia, you were voting for the 2 members or you were voting for the 3 members, depending on which cycle you were on. When you go to by-district elections, what that means is you divide up the city, and then each square or each pie shape votes for a member to represent them, which means that it subdivides the voting as well as subdividing who's allowed to run from that particular district. So if you are someone who is running for a city council in a at-large election, you're going to have to reach out to every resident of that particular jurisdiction. Whereas if you're going to be elected by district, you simply have to reach out to those members who are going to be voting in your district. It's a subdivision of that district.
Let me jump in and add one thing. You can tell when you look at the voting returns on contested elections if they're at large, because people will be winning with 28 and 29% of the vote versus by district, it takes 50% plus 1 vote to win by district. So the races tend to be decided in the high 20s and low 30s in the at-large races. That's a quick, easy way to tell if you're looking at the returns what type of elective model they follow.
We get jurisdictions to go from at-large elections to by-district elections based on certain criteria. However, we believe that by-district elections are more fair to underrepresented members of the community. And so what we're looking to do is to have a lot of voices be heard and have seats at the table. So we're trying to even out or level out the playing field. And so we do that by taking a look at who's currently sitting on those boards and whether they have a history of discrimination against certain minority groups. So this is where we now turn to the California Voting Rights Act. Jurisdictions that are refusing to go to district elections can be forced to do so through the California Voting Rights Act. I'm also going to talk about the Federal Voting Rights Act because it actually started all of this. But in California, we tend to go through the state system as opposed to the federal system because there's very different requirements. So when we're looking at the California Voting Rights Act, that was enacted or created in 2000. It was designed to encourage jurisdictions governed by elected boards, such as city councils or schools, to adopt by district elections. All 58 California counties, including Tulare, elect members to the Board of Supervisors by district. There's no longer any Board of Supervisors that's conducting their elections at large. And some of them had to be forced into going to district elections by way of lawsuits. So there's about three or four law firms that handle these types of cases. And some of them have been in this business since 2000 and have forced a lot of these jurisdictions to go to district elections through lawsuits. Most cities are also by district. However, some are still under the old relics of at-large systems and are holding on strong to maintaining their at-large district elections, but slowly they're being sued to turn over to district elections, successfully anyways.
And around here in the Central Valley, there's only two that I can think of, at least in the southern San Joaquin. One is the city of Clovis, and the other is Woodlake, I believe. I think everybody else has gone to district elections. Clovis will, my opinion, go down kicking and screaming. They don't want to go to district elections at all. And we're actually working up a lawsuit against them, which we'll file one of these days. Woodlake, they'll do it eventually, but Clovis is going to fight. But there aren't many jurisdictions left to switch.
Recent examples of jurisdictions that have been forced to switch by threat of a lawsuit or lawsuits include Visalia, who we had to sue in order to transition them to district elections, Porterville, Lemoore, Sierra View District Hospital. These are all lawsuits that had to either we threatened or we actually had to go forward with. Visalia was the first time, was an unusual case. When we sued to force Visalia to go to district elections, there were a couple of key issues that's turned up. One of the things was the fact that it was holding off-year elections. And by holding off-year elections, it suppresses the votes coming out. So people were getting elected with 13% of the vote, which is dismal. And so we wanted to make sure that we transitioned them to years where the governor as well as the president elections were being held. So it was the first time that a jurisdiction was forced to go to not only district elections, but also change their when they held their elections to coincide with the elections of the president and as well as the governor.
Oh, and one thing I wanted to add on that, and that case was a particularly big deal because the city of Visalia was the first charter city forced to explicitly violate a term of their charter, because the charter, which is like a city constitution, the charter actually had off-year elections as a provision of it. You can ask yourself, well, why would they do that? But they did. And so the court took up that issue, and that pretty much broke open all the rest of the charter cities trying to claim that their charter would prevent them from moving their election. Eventually, the legislature stepped in and simply, as a matter of state law, said all elections now for municipalities are either going to be in May or June in the primary or in November in the general election.
When you get elected to a position, one of the problems that comes up is even if you do want to change how your elections are being held, some jurisdictions believe that they're held hostage to the charter. So if the charter says you will hold elections by way of at-large elections, then you're stuck with that. It's your constitution. It's what you've agreed to abide by. So it's difficult sometimes for jurisdictions to voluntarily go to district elections. And so in some of these jurisdictions, Porterville, for instance, Porterville also had a charter that would not allow Porterville to go to district elections. And so we ended up having to sue them, although it wasn't a litigated lawsuit. It was a manner in which a judge could order the city of Porterville to go to district elections. But in order to do that, the city itself wasn't able to violate its own constitution, so it needed a vehicle to do that, and that was by way of a judge's order. to do that. So what is the CVRA, the California Voting Rights Act? In order to show that a jurisdiction has to go to by district elections, you have to show basically three things. One is you have to show that there's a minority population of at least 20%. I get asked a question all the time that says, well, when you talk about minority, what do you mean? I mean, do you mean white, Hispanic, African Americans? And what we're talking about in terms of minority is we look at the representation and history of possible discrimination. So if there's an area that is primarily white, and this tends to be the case because most elected officials are what we consider to be white under the rules for CVRA. If they have had a white board for their entire history and maybe one minority representative of whatever is the minority of choice, in the Central Valley, that tends to be Hispanic. In Visalia, for instance, we have close to 70% Hispanic population, and yet the city council had only elected one Hispanic or Latino in their entire history since the formation of the city. And that gentleman had only served, I believe, one term or maybe two terms before he was replaced by somebody of white. So we could also show that there was a history of discrimination. And what I mean by that is by the way that they were electing their members. It was causing a dilution of the vote. But when I get questioned about the minority aspect of the CVRA, there are some jurisdictions who only elect Hispanics and have never let anyone else sit on the board. And so there's no preventing a white person from filing a lawsuit saying, in the history of this city, you've only elected Hispanic members and there's never been a white person. Because in California—
We'll call it Woodlake, for example. Just
Woodlake,
hypothetically.
Right. Woodlake has, I believe, a 100% Hispanic board, and it has been that way for quite some time. No one can be elected unless you're Hispanic. So if somebody wanted to bring a lawsuit to change that so that more representation could be elected, they could do that successfully. We generally see more of the Latino population and the African American population being left out of the election process. And so those are generally what we're fighting for, is to even out the playing field so that those types of persons, those races, can be elected. But again, like I said, minority population, we're all minorities. There is no majority population in California. So when we're talking about the minority population being at least 20%, we're looking at the target population that is not being represented on that elected board. It doesn't have to be a minority in the traditional sense that we think of Latinos and African Americans. It can be whites as well. Secondly, we need a history of underrepresentation of that minority population. And what we usually do is we take a look at the traditional factors. For instance, have there been any prevention of people from voting? Are they failing to put out pamphlets that contain voting information in other languages, which is required? Are they putting people at the polling boxes that are turning minorities away? Are they doing all sorts of things that traditionally underrepresented members in the community have been having to face, preventing them from voting? Thirdly, we have a racially polarized voting. Essentially, polarized voting occurs when the minority group tends to vote for candidate A, but candidate B consistently gets elected because of how at-large voting works. We have statisticians we work with, actually demographers we work with, who have specialized
computer
programs that will tell them how the voting is occurring and will tell them if there's polarized voting occurring. We tend to think that if you are of a minority status. If you're Latino or if you're African American, you tend to vote for members of your community, of that particular race. But we sometimes see that despite this happening, they want to vote for that member. Other members are getting elected despite everything. And so we look to see if there's polarized voting, and we get the help from, like I said, a demographer who will tell us those numbers and how they work, and basically it's probability and statistics. So if you want a good course to take, which is a pain, it's probabilities and statistics, because that will actually help you out. So if that occurs, then the courts can order the jurisdiction to switch to district elections, which is what we're seeking. We're seeking them to go to district elections and change the way that the elections are being held. If a jurisdiction refuses to voluntarily switch, am I still being heard? Okay. If a jurisdiction refuses to voluntarily switch, then a trial is held. There's no jury. It's just a court trial. We put on evidence, and the defense puts on its evidence, and the judge will decide. There is a plaintiff in the trial. That plaintiff is in name only. They don't get any money. They don't really get anything other than their name is held out as the case name, as well as they will probably ask to testify. There are basic requirements, and we require that one, they be of that minority race that we are fighting for. Two, that they are a consistent voter. We don't want people who simply put their name on the paper and want to go forward. We want someone who's involved in the community and is active in the community. We tend to not put people as plaintiffs who have run for anything. Because we don't want there to be this idea that, oh, you're just sour grapes because you didn't win. So generally, they're activists in the community who know about the community, who have been here for at least a decade. But most of our plaintiffs tend to have been born and raised in the community. They know the community, they know the voting, they know the elected members. They're pretty conversant with everything. And like I said, the plaintiff does not end up getting any money from it, but upon a win, their name does get put in the books as having been the person who caused the change to be held. We have, sometimes we think that these are members who would be well suited to run, but so far, every person we've had as plaintiffs, not a one of them has actually run for those elected positions. They just want to serve their community from a civil rights standpoint, not so much from an elected board member. Okay, so who does get the money? So when we fight for these cases, the only person who actually gets paid will be the attorneys. And so there's an incentive for the jurisdiction to work with us to change the way that they're holding their elections, because if they voluntarily transition to district elections, then their costs will be kept low. But if they fight and we prevail, then they're going to have to pay our costs. In Palmdale, they refused to go to district elections, and the attorneys in that particular case, it was not us, by the way, but they ended up making, I believe, around $4 million enforcing that jurisdiction to switch to district elections. So not only did they have to go to district elections, they also had to pay the plaintiff's attorney's fees, which amounted to millions of dollars.
Which gives the jurisdictions a huge incentive to settle and not fight, because with the exception of Santa Monica, very few jurisdictions have won, in the sense if you define winning as being able to resist district elections. Even if they win, district elections invariably is coming statewide. So you can fight and spend millions and still ultimately lose. So most of the jurisdictions just go along with the inevitable. And if they cooperate, they have a lot more control, because if they cooperate, then they get to draw the boundaries, which kind of transitions into our next part of the talk. If they fight us, or a voting rights law firm, there's only 4 or 5 of us in the state. If they fight us and they lose the ability to draw the boundaries as well, because then the court's going to draw the boundaries. And Many times they don't like the way that that comes out, because what will happen is all 5 councilmen in the council members, in the case of a general law city, will find themselves in the same district. And that's amusing and ugly all at the same time. And so that one of them will survive and the other 4 will be gone. So if they cooperate, there's huge incentives. Additionally, they can control the timeline. With the national census coming down, the cases that we have settled, we've delayed the implementation to get past the census, because there's no sense drawing the boundaries in 2018 to then turn around and redraw it again 2 years later. So it works out to everyone's advantage if they cooperate, and certainly to the taxpayers' advantage, because it keeps the costs way, way, way down.
So you want to pull up your CBRA thing now? Okay, I got to step away from it. All right, there you go. All right, you want to ask them if they can see that.
Okay, can you enable screen sharing?
You should be able to do it because I have you as co-host, but let me check that again. There we go.
Did you hit that?
Let me try again. I think one of the Johns was and the other one wasn't. So we should be able to do it now. Yeah.
Click on. Go ahead.
Okay.
Yeah, it's on there. It's on there, Maggie.
Right? Okay.
Yes.
Okay, so what is the California Voting Rights Act? And I'm going to distinguish later the CVRA from the Federal Voting Rights Act, because when we get to redistricting, we're talking about the actual Federal Voting Rights Act and not so much the California Voting Rights Act, because as I will explain in a minute, there's limitations as to what the California Voting Rights Act allows for. So the California Voting Rights Act empowers minority voices in local communities. Okay, and why does it matter? Because a man without a vote is a man without protection. That was President Johnson's quote. So historically, the right to vote applied only to wealthy male landowners, which is, none of those is me, by the way. Over time, the right to vote, or franchise, expanded, now covering almost all citizens. With more people voting, it became imperative for incumbent politicians to control how the votes would be counted. And gerrymandering, or the use of at-large elections, were tools to prevent minority voters from asserting influence comparable to their numbers. So I have an example here of the snake of gerrymandering, which is really an example of how things would be gerrymandered. If you've never heard the term gerrymandering, it's when you take certain communities and you either pack them or crack them, and you put who you want to vote in a particular area and exclude other areas. So you're manipulating the manner in which the votes are counted in that area based on how you think they're going to vote. So for which candidate they're going to vote. And so you would take what was most beneficial to you getting the position and make it in such a way that you would be elected each and every time, despite the fact that you actually weren't the preferred candidate. There have been jurisdictions that have gone through such extents that it's laughable as to how it is that they're actually manipulating their gerrymandering. I take Lake Erie as an example. Ohio's so-called Snake by the Lake, 9th District. It stretches from Toledo to Cleveland. It's so thin and strangely shaped that they actually have to drive to Lake Erie to monitor sea levels with respect to the contiguity of the district, because you have to have a contiguous district. So they're concerned that Lake Erie will wipe out portions of that district, causing it to no longer be a viable district because of the way they've drawn it. Such gerrymandering to elect a candidate that is not necessarily the candidate of choice for everyone there, but just so that they can get a manipulated election count. In the every time they're redistricting, they have done this to maintain a particular area where certain people want to get elected in that area, and they're holding it basically by their nails. Other voter suppression tools include poll taxes, literacy tests, and physical residency. A poll tax has been nullified by the Constitution. There's no longer poll taxes allowed, but poll tax was basically when you go out to vote, to the voting polls, you were required to pay a certain fee in order to be able to cast your vote. Those have been found to be unconstitutional, and they're no longer allowed. Those tended to hit minorities the hardest, and so it was found to be a racially motivated avenue to get people's votes not counted. Again, literacy tests also affected the minorities the most, and the poor, and so those have also been found to be unconstitutional.
Other voter suppression.
Physical residence, those tended to affect people in the military. There's been a lot of issues, a lot of violations asserted that they're not being counted because you may be in the military, posted abroad, but you still reside in, for instance, Tulare County. We have a lot of members who are in the military, and their votes still should be counted in Tulare County. That is the constitutional way to do it. And yet a lot of those votes aren't getting counted because people believe that they're not physically residing here, and so they're no longer counting. Extreme gerrymandering can be a violation of the Federal Voting Rights Act. Let's talk a little bit about Section 5. In the Federal Voting Rights Act, there was a thing called Section 5. Section 5 punished those jurisdictions that had been especially bad with respect to violating voters' rights. The federal jurisdictions, the Department of Justice, determined that some jurisdictions were so bad at violating along racial lines, violating people's rights to vote, that in order to change any portion of their voting system, that they had to get pre-clearance. They had to get the okay from the federal government before they could change anything about how they counted votes. And that was called pre-clearance. Kings County was an example of one of those counties that had to get pre-clearance in order to change anything relating to how it conducted its voting. Also Monterey County, and there's several in California, but this was a federal issue. And so there were pre-clearance Section 5 jurisdictions all over the United States. In the South, there were quite a few. As you went up north, they tended to not be as many, but every state had a pre-clearance Section 5 jurisdiction, every single state. A few years ago, a Supreme Court case was filed attacking the pre-clearance requirements. Because it had been 20 years, more than that, since the pre-clearance statistics had been raised and litigated, the Supreme Court struck down Section 5 pre-clearance requirements because it said those numbers, that data was out of sync with today. And so it completely abolished all the Section 5 pre-clearance requirements. So now we're starting to see a reversion back to how things used to be before the Section 5 came into being. And so there's a lot of lawsuits now starting to get ready to go be filed under the Federal Voting Rights Act because of the lack of Section 5. It would not be surprising to me if in about 5-10 years, if there wasn't another Section 5 pre-clearance statutes put on the books with updated statistics and information. But in order to have something like that come on board, it will require quite a bit of work by the Department of Justice and a lot of work by law firms in those jurisdictions like us to file these federal lawsuits so that we can get the ball rolling on this. So what does the CVRA actually do? It authorizes lawsuits if the plaintiff can show that minority voting is being diluted or impacted by at-large elections. And the remedy is to switch to district-based elections. CVRA applies only to local elected boards, such as school boards, city councils, things of that sort. It does not apply to single elected individuals, such as the sheriff or the district attorney, because it doesn't make any sense. The reason why we're trying to go to district elections is because we have multiple members on the board. So if you only had one member on that board, you cannot divide up to have an election for multiple members. And so the district attorney, the sheriff, the county assessor, all those individuals where there's a single position, those are not controlled by the California Voting Rights Act, because it would just be nonsensical. How does it work? Okay, so we identify a plaintiff, a voter. We make a demand on the jurisdiction. We say, we want you to go to district elections because of the following reasons. And we cite what those reasons are. We say, we talk about the history of voter suppression. We talk about history of discrimination, things of that stuff, things of that nature, and also voter polarization. And we spell everything out. Then the government agency either complies and makes the change, or they refuse. If they refuse, a lawsuit follows. There are very strict timelines for the agency to comply. It's just a couple of months. If they don't comply, then a lawsuit gets filed, and then we start taking the process on to get them to switch. Once it's proven that they engaged in voter polarization and they violated the California Voting Rights Act, what can the court do to cure past violations? This is where, generally speaking, we spend the bulk of our time in the lawsuits. What do we want to cure the past violations? And what is the court willing to allow to cure those past violations? Usually when the jurisdiction loses, in other words, they're being forced to go to district elections, it's not just going to district elections, because we want to right a wrong that has been done for past violations. So oftentimes they'll say, well, we'll go to district elections in 5 years, and that's good enough. We will switch and we will draw the districts as we see fit, because under the charter, this is all our, we get to draw the lines, we get to determine who can be elected, all these things. So basically they want to remain the same and simply draw jurisdictional lines that they think are advantageous to them. What we have asked for in the past is we have asked for things like immediate election of all five new board members, including the prohibition against any of the current board members being able to run for the next 10 years. So we have asked for things like we have to draw the borders, we have to draw the district lines, we have to move when the elections are being held. With the city of Visalia, the court ordered that. We have some things that are the court has allowed and things that the court has not allowed. In other lawsuits, some jurisdictions have been forced to oust all 5 board members and start from scratch. And in one of them, the 5 board members who were tossed out were not allowed to run in the next election. So they basically had to sit out an election, and all 5 new board members have to come in. So there's a lot of different requirements that we can impose on them. The courts are willing to do things that are reasonable, but at minimum, the courts have always allowed or required that the jurisdiction do minority voter outreach and education. That has always been a requirement in order to cure past violations. And in Visalia, for instance, what they did was, I believe with the water bill, they sent out leaflets to every household telling them of the change in how the voting was going to be conducted and urging people to get out the vote. So there was actually a really good voter education and outreach program that was put into effect. Some jurisdictions want our input on how that should be done, and other jurisdictions just want to do it themselves. But we monitor the situation. We stick around for at least 3 years, sometimes 4, for the cycles to cycles to go through, so that we can see how it's working. When we say that we're voting for minority representation on the board, we're not forcing minorities to be elected. We're not telling a jurisdiction that you must elect minorities. What we're fighting for is the even playing field so that minorities can be elected. In some places, even though we have fought for minority representation and the CVRA violations, for instance, the city of Visalia, even though we were successful in the lawsuits, currently there is still absolutely no minority board members on the city council. On the other hand, we've sued the San Benito Healthcare District. There were 5 white board members. For years, they could not elect any minority members. Since they've had their elections after the violation of the CVRA, all 5 board members are now from minority communities. So it can be successful or it can be less successful. But once you have the playing field leveled out, the ability to vote representatives from your minority group increase tremendously. That's what I just talked about. Okay, where it's failing. The CVRA does not allow a challenge in state court for how the districts are actually drawn, which is why when we file a lawsuit for a violation of the CVRA, as part of the remedies, we remain vigilant about how those districts are drawn, because we're able to piggyback righting the past wrongs through gerrymandering prevention. So under the CVRA, although it doesn't speak directly to being able to draw the districts, because this is an order based on a past violation, we're able to demand that we have some say in how the districts are drawn. However, the CVRA is silent as to that. So if we were to find an area that had tremendous gerrymandering, we could not use the California Voting Rights Act to straighten that out, even if there was clear voter suppression. And a recent example is Kern County Board of Supervisors. They have gerrymandered the voting districts to such an extent that they're actually violating the Federal Voting Rights Act. They are creating voter polarization, and they're creating suppression of minority vote. Where does the CVRA need to go? Gerrymandering prevention and pre-clearance at the state level would be absolutely necessary in order to continue the path that we're on, in order to open elected boards to all minorities and everyone. In order to have community representation on these boards, you have to force these jurisdictions to do the right thing. And things such as gerrymandering prevention, pre-clearance at the state level, and for instance, a blanket requirement that all jurisdictions of a certain size transition to district elections would be the minimum. If the California Voting Rights Act allowed an additional level of prevention to prevent gerrymandering, that would go a long ways to allowing fair representation on these boards. So now let's talk a little bit about the Federal Voting Rights Act. Attorneys who are licensed to practice are licensed to practice generally in the states that they're going to practice in. So in California, we're licensed to practice law here. If you want to go to a different state, you have to take the bar there or somehow get in there under whatever means. In the federal system, generally, if you're allowed to practice in a state, you're allowed to practice in the federal jurisdiction of that state as well, but not necessarily. So in California, for instance, we practice in California, but we also practice in all in the federal jurisdictions that cover California. when you're filing a violation of the Federal Rights Act, it takes a lot more money, information, and it's a lot more difficult. So in order to fix these problems that are occurring where the CVRA doesn't quite cover them, such as gerrymandering, things of that nature, we have to go with the Federal Voting Rights Act. And in order to do that, there are very limited individuals who can actually take those cases up. We do those cases, but very, very infrequently because it's so difficult to get anything done in the federal system. Plus, they take decades to get anything done. So we're hoping that the California Voting Rights Act will be changed a bit to take on these issues that have come up and are the extension following the going to district elections, so that once we have everybody at district elections, we can move on to the next steps, which are how to draw district lines and get those things more fair to allow more people who want to run to be elected. And that's pretty much my presentation.
And it was a magnificent presentation. I'm serious.
Everybody needs to wake up now.
I'm serious. I have some questions. Actually, I have folks who, well, I have a couple of people that are on the Consul General of Portugal in San Francisco just said that she's fascinated by it. And so it was very well done. Obviously, we don't expect anything else from this team.
From a Portuguese lawyer.
That's right. That's right. So it was. I don't know if there aren't any other questions, but it was great, and I appreciate it very, very much. And for those of you who follow the California Portuguese-American Coalition, we're going to have a leadership seminar in August, and Maggie has agreed to be one of our workshop presenters. Yes, you did. John said you did, so I'm sure you did. You agree with John, don't you?
I do.
Okay, good. And because I think that this information, we're going to have 20 Portuguese-American young people between the ages of 20 and 33 who are interested in public service, and they need to be informed. We're going to have people from the Farm Bureau talking about, the ag policy, and of course this, and some politicians and some roundtables and everything else. But this was wonderful. Thank you so much. And before we let you go, though, I do need to have you do me a favor and give us the story, because we have people who have probably never listened to it. The story of when you came to Visalia and they were all surprised that there was a Portuguese lawyer. I love that story. So it's just very quick. And those of you following us, I think you'll enjoy it. And then we'll start our next presentation.
Well, when I came to Visalia, first of all, I had never been here. I came here because of the job. And I didn't even realize that there was such a huge Portuguese community, because in Newark, California, there was a huge Portuguese community, but I didn't really go outside of the Bay Area. So when I came here for a job, they hired me and I didn't know anyone. This was brand new to me. I didn't have family here or anything. So the first person they came to introduce me to was Judge Silveira, which some of you may know him. He's a Portuguese judge, and he's the Portuguese judge, I think, in all of the world. So they send me over there, and they come with me, and they introduce me, and they go, "Oh, this is and they, in Portuguese they call me Margarida, but and my real French is Marguerite, but then it's just Miss Melo. It's Maggie." So they say, "This is the woman we hired, the Portuguese woman who speaks Portuguese." And so he's like, "Oh, they don't even say my name or anything. They don't. This is a Portuguese woman." And I'm like, "Oh, this is great." And he's meeting me, and he says, "Oh, what dairy are you from?" I'm not from a dairy. I'm from Bay Area. I wasn't even like, "Oh, I don't even know anything about dairies." And I'm like, "Oh, okay." So then they go introduce me to the next person. They go, "Oh, this is a Portuguese lady who, she speaks Portuguese." And they go, "Oh, very nice to meet you. What dairy are you from?" I'm not from a dairy. It's like, why did everybody ask me that? And so a lot of people who would meet me, they kept asking me, "What dairy are you from?" And that I'm not from a dairy, but but I thought it was very strange. And then finally I just said, "Yeah, I'm from whatever, Silva." I don't know. Yeah.
Well, yeah, that's a lovely story. People always ask me, "What Borges are you from? Which dairy?" The Borges. I said, "We're from the poor Borges. We don't own a dairy."
Yeah, me too. Well, there's a Melo oil and petroleum down
There you
in
go.
Bakersfield.
That's
And
right.
so people would start, a few people have asked me, "Oh, are you from that Melo people?" You know, and I was like, "Oh, you mean the wealthy one? Yeah, yeah, sure, I'm from them."
Well, thank you so much, and appreciate it. Thank you, John, as well. Thank you
Thank
for
you.
for coming on board and being a wonderful Irish brother to the Azorians, and hopefully we'll see you soon, and we'll see you. And when are you planning to go to the Azores? There was
God, as soon as we can.
Yeah,
Okay.
we got jammed up in COVID. We were going to go there for our honeymoon. We got jammed up because of
I
COVID.
know,
So
I know.
maybe next summer, I guess. I
Yeah,
guess things are
next
still
summer.
tight.
Next summer's the best time. Yes, indeed.
Yeah,
Yeah.
my
Thank you
uncle
all
has
so
a
much.
place there, and I have lots of family still there, and so I've been there, and they are so warm and wonderful, and all they do is feed me all day long, you know. So I'm waiting until I lose a few pounds so I can gain them when I go
Yeah,
there.
well, if I was going to wait for that, I'd probably have to wait until I'm in a casket somewhere. Anyway, thanks to both of you. I appreciate it.
Thank
That was
you.
very
Thank you.
nice.
The only
and
thing I
we'll
wanted to
touch-
add is if anybody has any specific questions about the CVRA, they can always get a hold of us through Denise.
That's right. Yes, please do. Thank you so
Muito
much.
obrigada.
Obrigado, eu. Muito
Até
obrigado.
logo.
Até
Thank
logo.
you.
Obrigado.
Bye.
Obrigado. Thank you so much.
Bye.
Appreciate it. Thank you.